Ladies and gentlemen, welcome to my channel. Today I'm privileged to have Hunter Josiah, one of my friends. It's good to have good friends, because when you have good friends, you have good conversations. And today you are privy to that conversation when we talk about succession, wills, and how to go about it. This is a conversation that many people are not willing to have. And many people go the last minute to complicate so many things. Things that could be simple have been made so complex, especially after the death of the person who is concerned. And today I bring forth Hunter. Hunter is an advocate of the High Court of Kenya, has 10 years experience in this field of law. And he has a private practice in Kisumu, Kenya. And he's able to help individuals with the same issues of successions, wills, trusts, and he is here to shed a little bit more light on this. He has expertise in commercial law, in succession, in conveyancing, and many other things that he does in his private practice, and we'll be able to share details on how you can be able to get to speak to him and have conversations and be able to engage him further. So we will have in the description box his email, maybe his phone number, his website, so that you can be able to follow and be able to engage him on any of the items, this one or any other items that he may be able to speak about. I hope that this is the first of many conversations that we'll be able to have to debunk many, many conversations about money and the legal infrastructure in Kenya. So thank you. Welcome, Hunter.
George, thank you for having me. And definitely, I do practice in Kisumu, but I cross county boundaries, I cross country boundaries, so definitely able to help with wherever an individual is, whatever the jurisdiction is.
Thank you for confirming that. And yeah, so today we're going to go straight to the conversations on the wills and succession. So maybe to start with somebody who doesn't understand, what is a will, Hunter?
Well, and thank you for having me. One of the things that I was hoping we would do on this particular session is just simplify everything and make it as clear as possible for anyone who wants to know about wills. My definition of a will in its very simplest form is a declaration, and maybe declaration may be a hard word as well. It's just a statement or with regard to your property. It's really as simple as that. So you write something down or you say it orally, and you're confirming to people around you that this is what I want to happen to my property. I can't put it any simpler than that.
Okay. So it's a written declaration. So should it be written, or should it be verbal, or is it both? Either or.
So what the law in Kenya provides for is you can have an oral will and you can have a written will. Now, when you go into a written will, you definitely put something down and have it signed, and we'll get into the confirmation, the procedures related to that slightly later on. Or you can have an oral will, and even with that, there are certain requirements that the court will to confirm that the oral will is valid or a written will is valid. And you're right, and when you started off, you did say that having this conversation about succession, having this conversation about death is not something that people are very happy to have or would want to have it very openly. The one thing I'd like to say as we take stock of what we're discussing is, when you pass on, there are two situations, the two scenarios that can occur. One, you can either die having written a will or having stated a will, like you're saying written or oral will, or secondly, you can die without a will at all. And the first instance, where you have a written will or where there was an oral will, is what we call intestate. You die intestate. And a lot of people have come across this language, so it's important for me to demystify it. Dying intestate is dying without a written will or without an oral will. Dying testate is dying with a written will or where there's an existence of an oral will. So intestate, dying intestate and dying intestate are terms that people will be conversant with as they go along and through their life.
Okay. So yeah, thanks for mentioning about a will and confirming about whether written or oral or and what it means in the legal sense of things. Let me take you back a little. We see in movies, let me just talk like a layman, in movies where people call individuals and they speak on their will, like the potential beneficiaries in a will. Is it a requirement, and for the sake of avoiding conflict and disagreement, to invite the people as you write your will or as you announce or declare? Is it a requirement or is it by choice, where you call your independents to say, hey, when I die, this property comes to you in the presence of others for the avoidance of doubt, or is just that a practice somebody may or may opt not to?
So within Kenyan law, and again, I'm going to try and simplify it as much as I can. And let's start with an oral, a written will.
Yeah.
When you have a written will, it's a requirement that you have two witnesses, and two witnesses who are not beneficiaries. Let's say, for example, we've got Tom. Tom has his wife, Nyambura, and Tom has his children who are, let's say, slightly older than, let's say they're mature children, they're over 18.
Yeah.
Tom has his son, Tom has his wife, Nyambura, Tom has his children who are over 18, and then Tom has other people in the room. So he would be writing his will, but when he's writing his will, there is no requirement, there's no legal requirement that the people who are witnessing will know the contents of his will. So that's a very important aspect that needs to be considered when people are putting together a will. The person who is witnessing an individual sign a will is only witnessing that he's putting the signature onto the will, so they would subsequently, as soon as they've witnessed that, also append the signature to the will. So those two individuals need to be persons who are not beneficiaries to the will. Let's say, for example, Tom decides that he wants to bring his two best friends to sign on the will as witnesses. They must not be people who are benefiting from that will in any way. If there are people who are benefiting from that will and they're signing as witnesses, there's a chance that that will be declared invalid. Same scenario when you're having an oral will. Now, more often than not, when someone is declaring their intention with regard to their property, they will sit in a place, have their family close by, but it's also equally important to have people who are not family members for them to confirm the declaration that someone has made. So by practice, by law, it's important to have witnesses who are not beneficiaries. So that is the practice that has been going on for a number of years now.
Thank you. Thank you for clarifying that. For us who watch a lot of movies on successions and wills, to be able to understand whether it has been done for dramatic purposes and is it applicable legally in Kenya or not. Then on to the next question, which is a living trust versus a will. What is a living trust versus a will in terms of the operation and how they are executed?
Okay, and for that, I probably, if I think back to some of the few clients that I've had an interaction with regard to living trust, which can sometimes, and it depends on how you look at it. And I'll probably start with the definition of the word trust, people who set up trust. And there are a number of definitions that I want to sort of clarify. There's what we call a living will, and some people call it a living trust, and sometimes the definition gets merged in one way or another. So I'm just going to stick to a living will. A living will is a declaration while you're still alive, what you want done with regard to certain things. And the one moment that we have interacted with this is when someone says, I'm still alive, and I would want you to do X, Y, Z if I'm possibly in a state in which I cannot do anything. So some people become ill and they're in hospital for a long period of time, and some of the property has to be dealt with within that period of time, but they're not able, for one reason or another, to sign onto that document, to come out of a coma and do that. So that, in reference to that, that's what I would call a living will, and that is used many times within other jurisdictions outside of Kenya. Not very common in Kenya, but I think it's gaining traction, and people realize, particularly when they become unwell, what happens in that scenario. So then that differentiates from a will. A will talks about when you have passed on. However, there's certain instances where we have drafted wills and beneficiaries are aware about the contents of the will, and in those wills, someone decides to put a clause there saying, I will set up a trust within 2 years. Now, they may not die in that 2-year period, but they'll be setting up structures to enable that happen. So I would say anything that talks about a living will versus a will itself, one talks about what happens after a person has died with certain tweaks to that document, whilst the other one talks about you're still clinically alive, but there's certain things that you would want done within that period. That's how I would look at that definition of living wills, trusts, and wills themselves.
Thank you for clarifying that fact. And it's important that you mentioned about clinically healthy versus when you are sick and you want something, to be able to operationalize while you are unable to, physically be able to do things. And there's so many wills that have been contested on the basis of the person was not in their sound mind as they were writing the will, or the person was under duress, or somebody unduly influenced the person to maybe give them more properties and all these things. Or maybe they wrote this will when they were not in good terms with somebody. So in a way, being in a state where they might give somebody more property than the other based on their feelings at that point in time. But I want us to pick that conversation later on so that we can be able to talk about things that would challenge a will that has been validly done. And what are the possible remedies of such an issue? So now to my next question. I am fairly healthy.
Right.
I'm fairly young. I am thinking about building wealth. I'm not thinking about death now. I'm not looking at succession now. So why is it important at my age to be able to write a will? Why is it important to be able to, set up a plan now, even though I might think I'm not yet at that point? I mean, even people who are 50 and 60 still don't think that they're at that point. People assume that I look for Hunter when I'm 60, I'm in retirement, and I'm probably having some health condition that might challenge me. So why should I write a will at my age, or even at 50 or any other time?
Yeah, and it all boils down to the stresses of life, and that's the way I would tell it. Do you want your family to be stressed? In addition to you passing on, do you want your family to be stressed about how to decide the disposition of your property? To decide how to share your property amongst everybody if you're not disposing of that property? Now, you want to create some level of certainty for your family, and that's one of the things that I think every lady, every man should do. Prepare the family for certain things. And this is one of those things that I think is fairly important. You just want to leave everybody in a state in which they are comfortable, they understand what their wishes were, and they will fully implement those particular wishes. So I would say out of prudence, out of caution, so that there are no intricacies, disputes within the family, and again, to leave your family behind whilst they are stress-free. I mean, again, I'm being as simple as possible. There are situations where we have seen families fight every now and then regarding property. I remember just yesterday, a client came in and we're having a discussion about how they have not, a patriarch in the family passed on, and 2-3 years down the line, they have not been able to decide how to distribute the property, even though the client was keen, had started the process of drafting a will, had started the process of initiating a trust, but unfortunately passed on before that. 2 years on, there's a lot of fighting. And question is, you want that fighting to be something that becomes the hallmark of your family. So whether you're 18, whether you're 35, whether you're 40, whether you're 50 or 60, the right time is now. The right time is not tomorrow, it's right now. Listing down your assets, listing down your liabilities, and the reality is no one knows the time or the hour when we will depart from this world.
Thank you. Thank you for talking about it. And I think maybe I would want to share on the point of, you've talked about families and children and being married. What if somebody doesn't have children? Because children is not automatic that you have children or you want to have children. So what if you don't have children or even a spouse? Can you still proceed on and pursue a will? And if you choose to pursue a will, if you have, say, children who, this is a second question to the question that you talked about earlier, about trust and wills, can you be able to set up a trust on behalf of a dependent should you think the person is either incapable or unable to maintain the wealth that you entrust unto them? Can you be able to do it within the will, have a trust to be able to sort of provide maybe for their education or the education of their children or something that is managed professionally out of the direct hands of the individual? So maybe before you can think about that bit, but maybe that bit of if you don't have children or a spouse, should you still pursue that possible option, having a will?
Yeah, and that's pretty. It's a good question with regard to understanding what to do in such a scenario. But remember, the initial understanding of why a will is written is for you to decide how to dispose of your property, or what you give. It's a declaration of what you want done with your property. So therefore, your property can go to your friends, your property can go to your parents, your property can go to your siblings. That is a decision that you would have to make. The caution that I would place forth as people think about this and what we advise clients, the first thing I ask them is there anybody who is dependent on you? Because that's a very critical thing. Some people live alone but are actively supporting a sibling, actively supporting a parent. In that regard, a spouse, not having a spouse does not mean, or not having children, that does not mean that you have no beneficiary or doesn't have no dependents. So the first thing we always ask people is, who is depending on you? Because the fear that we may have is, even if you've written a will, and that means you have died testate, or even if you've not written a will and you've died intestate, there may be a possibility that someone can come court during your succession process and say, raise up their hand and say, I'm a beneficiary, or I'm a dependent who has died. Therefore, I demand a stake in their property. That is the greatest fear. So the issue that overrides is, do you have people who are dependent on you for us to determine why you should or whom you should be? There have been situations where people have drafted wills and have excluded certain people, like you, but then they go to court as objectors I've been excluded from this will, but not right. It's not fair. It's not equitable. I was a beneficiary. I'm a dependent on this particular person. Therefore, I'm entitled to at least have a stake in their property. And courts have come forth and made judgment. Yes, based on the evidence that has been presented to us, you do have a claim on this property. So that is important to understand the issue of beneficiaries or dependents. Even if you want to exclude someone from your will, you must consider whether they are dependent, otherwise that will can be what we call can be set aside.
Yeah, thank you for your answer. Maybe we can now go to another question as we think about a few other things that we've already talked about. And that is, how is now the will executed? So you've written a will, you've done all the legal things the way they're supposed to be done, and you have now passed on. So what happens now?
Right. So essentially, let's assume that you have done things the right way. And one of the things I always advise people when you're writing a will, imagine it to be as simple as possible. And some of those provisions are there under the Law of Succession Acts. There's some ingredients to a will that should be there. And this is where I would encourage people to seek guidance of a lawyer so that you don't write statements that cannot be realistically applied within a will. So lawyers would be able to guide on how to structure the wills or how to write it, again, without too flowery language, what we call legalese. Assuming that is all done, you signed, you had two witnesses, you kept the will in a particular place. So there, and again, I remember one time when we were doing a legal clinic here in Kisumu, there was a contention about the existence of a will. And a lady came to us and my husband without a will, thereby dying interstate. However, one of her stepchildren in Canada came back and said, whilst my father was in Canada, he wrote a will on that side. And that's an issue, that's a fairly contentious issue, because it then goes to the root of, when you do write a will, who do you keep it with? Do you keep it with a lawyer? Do you keep it with a friend? Do you keep it with a business associate? You need to understand who is neutral in the circumstances, how many copies you can keep. That discretion is left to the person who is drafting the will. So what would essentially happen? Whomever you kept it with, hoping that they don't pass away, upon knowledge that you have passed on, we'll go to the family on very fairly informally and say, this gentleman died with a will. And if it's a lawyer, they'll go to the family and say, there was a will that was written. Can I read it to you now or can I read it to you later? Because sometimes what we do in the wills is we cater for expenses such as death and who's going to cover the costs, where that money is going to come from. And sometimes people rush to court pretty quickly to understand whether we can use some little money to cater for X, Y, and Z. There may have been some insurance that was pegged on someone's death. So one of the recommendations very early on is whomever has the will to read it out. And if they've got knowledge of the contents, to read it out and say, this is what the deceased has intended for distribution of his property. It may be that X property goes to X, Y, and Z, or to cater for my funeral expenses, this is what is covered. In some scenarios, it is a judgment call by the person who is reading the will or alerting the family to the existence of the will. Because reading a will at a very early stage can also be a recipe for chaos. So it's not, there's no hard and fast rule when someone has passed on, but if there's someone who is aware of the contents of the will, it would be prudent upon them to make a judgment call and say, perhaps we should read the will at this time, before burial or after burial. And then once the will is read, you see now, you will then decide how to approach the issue,
Yeah.
whether, when, and how to go to court. Because, and I was discussing with some of my colleagues, you do have to go. There is no shortcut to succession.
Yeah.
You either go to court, whether the deceased has died, you go to court knowing the deceased has died interstate, there is no will written. And there are different processes that cater for that. The courts in Kenya have allowed for different forms to be filled when someone has died tested, when other forms to be filled and applications made when someone has died intestate. So a lawyer will be able to provide guidance on how to go through that process, whether someone has died having written a will, tested, or not having written a will, intestate. But the intricacies of when, particularly in a situation where a will has been written, when to read it, when not to read it. That's why we always encourage people, as they write the will, they should be aware that if there's something that is critical to the will, within the will, that needs to be read out to family members prior to interment, whether it's cremation or financial resources being put to the funeral, it's important that someone is aware of that and they can read it to them at the appropriate time.
Okay, thank you so much. I think